You may begin.
Okay, welcome everyone to our forum on the final report of the Special Committee on the Delivery of Legal Services. We are joined today by our representatives of the Florida Bar Board of Governors, Saya Baker Barnes, Robin Bresky, Michael Gelfand, and Ron Ponzoli. The format for today, we're going to ask you to type your questions into the chat feature, and I will be calling on you to actually speak with us and ask your question or provide your comment. We're going to begin with some PowerPoint slides that will be shared by each of our Board of Governors reps. So Saya, I believe you are going to start.
I am. Thank you very much, Julia. Thank you all for attending today. It's good to see everybody. So the 15th Circuit Board of Governors, and if everyone could please mute themselves if you're not muted already, so that we just have one person speaking at a time. But we in the 15th Circuit wanted to host this forum. It's one of many being held around the state, and it's an opportunity to provide our members with a chance to be heard on the final report of the Supreme Court's Special Committee to improve the delivery of legal services. This is a committee that was established by the Florida Supreme Court on November 6, 2019. It is not a Florida Bar committee, and it was not established by the Florida Bar. And in the slides that you'll see in just a moment, we'll provide to you the names of all of the folks that served as committee members in case you want to reach out to them directly. That said, our role in this process as members of the Board of Governors is, like you, to review the recommendations, to educate ourselves on the recommendations, to hear from all of you and others about your concerns, your thoughts, your perspective on the report. And then we will be having meetings with the special committee coming up on September 8th and October 26th. Those meetings will be held between the special committee members and the Board of Governors members, so that we have an opportunity to get our questions answered about the report, as well as your questions answered about the report, and address any concerns that you may have. So if you could, I think we still have some folks that are not muted for some reason, so please mute yourself. So again, the dates of those upcoming meetings are September 8th and October 26th. So a couple things. We want to assure you that we will remain available to you throughout this process. So feel free to reach out to myself, Robin Bresky, Michael Gelfand, Ron Ponzoli, or any of the other Board of Governors representatives with questions that you may have. We'll try to get them answered for you. And we, as members of the Board of Governors, don't have the final word on what happens with these recommendations. Our role in this process as a Board of Governors is to vote on our positions on the report. That will happen on November the 8th. And then that vote will be submitted for ultimate decision by the Florida Supreme Court. So at the end of the day, the decision as to what happens with this report ultimately is up to the court. But it's important that we hear your input and that the court hears your input on these matters. So to make your voices heard in the chat, there is an email address. It's scinput@floridabar.org. It's already there for you, and it'll be in our presentation. And you can feel free to express your perspective at that email address. There are also a number of resources available to you. I've put a link in the chat. We put a link in the chat to the website that contains all of the special committees materials and reports, so that you can take a look at that as well. And I'm going to share my screen now, hopefully, if I can, to start the PowerPoint presentation that we have for you today, just to give you an overview of what we know now. So hopefully everyone can see that. A little bit of background on the special committee. Again, it was established by the Florida Supreme Court in November of 2009. And the committee was asked to address the following topics: lawyer advertising, referral fees, fee splitting, entity regulation, regulation of online service providers, regulation of non-lawyer providers of limited legal services, and such additional topics consistent with the subject of the study as the committee deemed necessary. This is a list of the committee members and their backgrounds and their locations. And again, this information is also available in the final report that the committee submitted. As we understand it, the committee was broken into several subcommittees in order to study the various subtopics of which there are recommendations. Those are review of Rule 4-5.4, professional independence of a lawyer and accompanying ethics opinions, review of pertinent advertising rules found in Chapter 4-7 of the rules, review of Rule 4-717 related to payment of referral fees to persons other than lawyers, review of the lawyer referral services under 4-722, review of the regulatory framework, including regulation, regulatory sandbox, and other related concepts, member and public engagement and data collection and review of the advanced Florida registered paralegal proposal. The final report does contain several recommendations, which we'll go over next. And again, please put any comments or questions that you have in the chat. I will just reiterate to you all that this is a report from a special committee, not from us. We'll do our best to answer any questions and concerns that you have today, but there may be questions that we don't have answers to. I can just assure you that if we don't, when we meet with the committee on the 2 dates that I gave you, we'll certainly do our very best to get those answers for you. I'm going to turn it over to Robin Bresky.
Thank you, Saya. And yes, just to reiterate that there may be more questions and answers, and we also have questions, just to let you know. So I'm going to go ahead and go through these slides, and we can discuss that at the end, or please post the questions in the chat. So review of Rule 4-5.4, professional independence of a lawyer and accompanying ethics opinions. So the committee suggested that Florida follow Utah, and they unanimously voted to approve the concept in the following recommendations. The recommendation was to amend Rule 4-5.4 to permit non-lawyers to have non-controlling equity interest in law firms with restrictions. The approved concept is similar to the Washington, D.C. rule and allows for non-lawyers to have a non-controlling equity interest in the law firm with restrictions. Specifically, the work of the non-lawyer has to actively support the work of the firm. The special committee explicitly voted that the professional rules should not be amended to permit a passive ownership of law firms. The review of Rule 4-5.4, professional independence of a lawyer and accompanying ethics opinion, to continue. If passive ownership is explored, it should be done in the context of the proposed law practice innovation laboratory program so that safeguards can be put in place and data collected. And in the report, you will find some explanation of the laboratory program. So the recommendation within the law practice innovation laboratory program, eliminate the restriction on fee sharing with non-lawyers under Rule 4-5.4. And the recommendation, again, was to amend the rules to allow for not-for-profit law firms. Again, under 4-5.4, they approved in concept, the committee approved in concept, amending the rules to permit not-for-profit legal service providers to organize as a corporation and to permit non-lawyers to serve on the not-for-profit legal service providers board of directors. And this conforms to the rules that are currently the current practice. As noted, the recommendations anticipate that if the recommendation to establish a law practice innovation laboratory program is adopted by the court, all or part of the recommended changes would be placed in the lab for implementation and study. And then under Chapter 4-7 of the rules regulating the bar, the recommendation was that the committee, I'm going to be turning this over. This is the advertising portion of it, and we're going to turn this over to Ron to talk about advertising.
Okay, well, thank you, Robin. So the review of the pertinent advertising rules, Chapter 4-7, the recommendation was that the committee unanimously voted to approve amendments to the advertising rules and concept. The committee found that these conceptual amendments would streamline the advertising rules and would make the language of the rules more succinct and could eliminate any processes or requirements that are no longer as appropriate or necessary as they may have been previously. Then with respect to the rules concerning lawyer referrals, Rule 4-7.22 and Chapter 8, which concerns not-for-profits, the committee agreed with the subcommittee report that there should be no amendments to those rules. So those would stay unchanged. And then and this is a concept that you all are going to hear us talk about a bit today, and Robin already made mention to it, this laboratory program, or the lab. The committee voted that the court, this is the Supreme Court, should establish a regulatory sandbox where the recommendations approved in concept may be tested and data collected. The regulatory sandbox, as I said, is referred to as the Law Practice Innovative Laboratory Program, which is a mouthful, or simply the lab. And although the committee voted that the lab be established, the format was approved in concept only. So this is a concept, everyone, and it is subject to comment, observation, input, and certainly development. But as Robin mentioned, there are attachments or an appendix to the report that does lay some of the framework out for at least how the oversight would work from the court down to a supervisory board with respect to the sandbox. And I would commend all of you who are interested in this piece of the report to review that appendix. And then I believe this was for me, Michael, I hope I'm not stepping on your toes. Review of the Advanced Florida Registered Paralegal proposal. The recommendation, the committee is recommending that Florida explore this option by approving a pilot program, allowing Florida registered paralegals to provide limited legal services in specific areas within a law office. So again, this is a pilot program that would be tested in the lab. The limited assistant paralegal pilot program would allow a qualified registered paralegal to assist a client in preparing and filing legal forms, provide some information to the client regarding their legal matters, and provide ministerial assistance in court proceedings. And again, the committee did not recommend a rule change, but instead recommended a pilot program be included in the Law Practice Innovative Laboratory Program, the lab, so the concept can be tested. And with that, I'm going to turn it over to Michael Gelfand to take us through the balance of the slides. Do we have Michael?
I think Michael may have dropped off. Are you back on, Mike? He was having some technical issues.
Thank you, Ron, for the handoff. And a bit of what may be potpourri at the end, we have additional committee action by the Supreme Court's Select Committee, Special Committee. The committee voted to recommend to the bar that the bar promote a better understanding of Rule 4-1.2C. This rule allows lawyers to limit the scope of their representation and provide unbundled legal services. As noted in the comment to the bar rule, a limited representation may be appropriate because the client has limited objectives for the representation, or because the client may wish to exclude actions that the client thinks are too costly or which the client regards as financially impractical. And that's the comment to the rule. The Supreme Court Special Committee found that although this option is available to both the lawyer and the client, this option is underused. Providing education in this area will help lawyers understand the rule. With better understanding, the rule may be utilized more with clients reaping the benefits. Finally, we return back to the concept of the lab, and the formal title from the Florida Supreme Court's Special Committee is the Law Practice Innovation Lab Program. And most of the recommendations that the committee made are changes in concept only, with the changes taking place in what the committee referred to as the controlled environment of the Law Practice Innovation Lab Program. A lab, or what they refer to in shorthand as a regulatory, quote, sandbox, unquote, is a mechanism where the Florida Supreme Court, or a body appointed by the court, permits entities that may be different from a traditional law firm to offer new and innovative methods, ideas, and types of legal services without a wholesale amendment of the bar rules. The Florida Supreme Court Special Committee recommendations included that a lab participant be licensed and allowed to continue offering its services after the lab formally concludes, unless there is an evidence of harm to the consumer. With that, a reminder that the Florida Bar and your Board of Governors seeks your feedback. On your screen and in the chat is the email for your feedback, and that is scinput@floridabar.org. Please let us have your additional comments, concerns, and questions. Julia, turning it back over to you.
Okay, so we do have one question so far. Everyone, please remember, put your questions in the chat feature, and then I will call on you to ask your question. So we do have a question from Robin, and it actually is similar to another question that we have. So this is for our Board of Governors reps. For the paralegal pilot program, the report says that the Florida Bar's family law section and reptile sections have not been consulted on the language in the outline and have not given input regarding the pilot program. There is concern about why the sections are not being given the opportunity to provide their input. Can the Board of Governors reps ask that more time be provided to allow the sections to weigh in? Does the Board of Governors think that it is important for the sections to weigh in on this before the bar spends significant time and money on this pilot program?
Julia, this is Saya. I can certainly jump in on that. Anyone else can if they want. So, hey, Robin, it's good to see you as always. To answer your second question first, from my perspective, I think it's critically important that anyone, whether it's an individual lawyer, a section of the bar, or what have you, weigh in and give your perspective on the recommendations in the report. Right now, we do not anticipate the Supreme Court making any decision on this before our vote in November. And so it's our expectation that anyone who would like to weigh in on this issue and provide input to the bar has the opportunity to do that before that point. So I would encourage you to submit whatever information is deemed necessary. If the sections want to submit a position on this, certainly by all means do so, so that all of those perspectives and concerns can be heard. More time. I'm not sure about that. I do know that a timeline has been established. That timeline includes, as I said, the 2 meetings with the committee in September and October, and our vote in November.
As a follow-up to that, I know that there are other sections that are looking at this, and we do urge them to provide their questions and comments. I know that the real property, probate, and trust law section is starting meetings later this week to frame their questions and comments. How the Florida Supreme Court handles the formal comment period, I don't think we've seen anything on that yet.
Okay, we don't have questions in the chat, but we have questions that have been provided to the bar before this forum. So our next question is really a concern and a comment. There is concern about whether the committee looked at other states that address access to justice through greater provision of funds for legal aid. For example, Texas works closely with their legislature to ensure millions go to legal aid annually. Our members would like the Board of Governors to ask the committee to provide more information about whether they studied Texas and spoke with anyone at the Texas bar about how they help to ensure access to justice. Ron?
Yeah, thank you for the question from whomever it came. And I think that is a fair point, and we certainly will, when we speak with the committee, ask that question and questions that surround that topic. Keeping in mind, everyone, as Saya may have said, I believe said at the beginning, we ourselves, your representatives here have questions, many questions. So we will carry that question and the balance of questions that were submitted into the bar to the committee, and we'll ask those questions. So thank you for that input.
So we have a question from Sean Dominic. Sean, do you want to unmute yourself and ask the question directly to our reps?
Sure, I can do that. Hi, everybody. Thank you for doing this afternoon on such important issues. I appreciate you guys, the hard work that you guys have ahead of you as you're trying to navigate this. You know, the first question that comes to my mind is, how do these proposals help the lawyers? I mean, especially since so many of these concepts were robustly discussed, debated, and resoundingly refuted just a couple of years ago. So how is this helping lawyers?
So Sean, hi, it's Saya.
Hey, Saya.
Good to see you.
Likewise.
So I have the same questions that you do. And those questions have not been answered for me yet. So to me, when I look at some of the proposals, my thought is always, listen, these have been well-established rules for a long time, and they've been rules that are in place for a reason. And so to stray from those rules, we got to look at the risk and the benefit, and I would have to have some very significant benefits to consider. And I don't know the answer to that question. So those are questions that certainly I have, that I intend to raise at our meetings with the special committee, to know what is the benefit of this and what are the risks. And some of them we've already sort of raised and addressed, as you mentioned, when some of these concepts were raised previously. My concerns about those concepts haven't changed, but I think, obviously those are critical questions that we need answers to that we don't have yet. But you can, rest assured that we will be raising them.
And Sean, thank you for your question. I want to add also, different than 2 years ago, the origin of where we find ourselves with this report is this comes from the court. This isn't the bar, the board suggesting that we do this look, or at least the origin of it is the court putting this in motion. So that's how we find ourselves in this moment of time and doing this review. But I echo Saya's and I know Michael's and Robin's thoughts as well. As I said a moment ago, we have a lot of questions, and we are looking forward to visiting with the committee and addressing those, the one that you raised and a lot of others. So thank you.
This is a nationwide coordinated campaign that's happening right now. California is fighting it as well. And so I think clearly it came from the court, but the question begets, what was the motivation of the people that approached the court with regard to this as well? And I'm sure you guys are going to be looking into all that.
And we are very lucky to have Skip Smith with us today, and he's posed 2 different questions in the chat. Skip, would you like to unmute and ask your questions directly?
Sure. Hello, everybody. I'm so happy to be part of this, and thanks very much to our 4 Board of Governors representatives for all your hard work. I know how much time that takes. Appreciate your devotion. Yeah, and recognizing, just one side note, if I might, just because something's been a rule for a long time doesn't necessarily mean it's still a good rule. There's a quote from an ancient case that no degree of antiquity makes a bad habit a good one. But I tend to remember that. But anyway, my one question I had was the recommendation about expanding what registered paralegals could do correctly says that they must do it within a law firm, which I take to mean they have to be employed by a law firm. And I question whether that's really an effective expansion of what's already happening. I seriously doubt it. It may not be the board's place to try to expand on the recommendations of this committee. I don't know, but I don't think that, if I'm interpreting that correctly, it's really expanding anything that's already happening, as opposed to paralegals, be independent paralegals providing these kinds of services. Secondly, on the non-lawyer ownership, it's just a question. I think it's probably time for that in a limited way, probably has been for some time, but I agree that passive ownership would be dangerous. I agree with the committee's recommendation not that not be permitted, but then what does passive mean? As I read the recommendation, it says that the non-lawyer owner must, quote, this may not be an exact quote, actively support the work of the law firm, end quote. It doesn't say that person has to be an employee of the law firm. That could be an important distinction, it seems to me, if I'm reading it correctly. It may not be. So there could be somebody that actively supports the work of the law firm could be somebody that the law firm does not employ, much less controls. But that person would have a vote on, I guess, who's on the board of directors of the law firm and all, depending on how it's structured. Just something to think about. And finally, this is just a technical point. Bob Burdish and I have discussed this in the past about the nonprofit law firms and how the rule doesn't really permit law firms, and a legal aid society is a law firm under the definition, under the rules. But the rules don't permit lawyers to work in the form of a corporation. So this amendment is needed, I believe, and also to permit non-lawyer members of the board of directors, which, as the committee report says, is current practice. It's happening all over. I just wonder whether that, but I think probably, this is technical, that should be an amendment to Rule 4-8.6, not 4-5.4. Those were my points. Thank you for letting me raise them.
Thank you.
Robin, did you want to add anything?
No,
Can I
no,
just add one thing? Can I just add one thing? I'm sorry. Regarding the advertising rules, it's way past time for this to happen, for the simplification of the advertising rules. They are just draconian, and lawyers get tripped up on them all the time, and it's not helping the public to have these draconian advertising rules. Anyway, thank you.
No, I was just going to thank Skip for his comments. As always, they're appreciated. But I think with regard to the active supporting, that's a very good question that we can bring to the committee about what is the role of actively supporting versus the passive. It doesn't have to be an employee context. I think that's an excellent question for the committee.
And I was going to follow up, Skip, and thank you also for your continuing volunteer efforts on the Professional Ethics Committee and other efforts. With reference to the paralegals, many of the questions is going to be the devil's in the details, and we don't know where that's going to be and what the Florida Supreme Court is going to be recommending or putting in place. You've got the information that's there. There's a question as to how much supervision can actively occur if someone is going to court. And I believe that the report specifically says that needs to be fleshed out. There is some more information in one of the appendixes or one of the exhibits on that. Thank you.
I see Lori Briggs had a question. Lori, would you like to talk? Lori, are you still on?
I am. I mean, I'm fine with it being read or saying it. I'm trying to figure out the impetus for this rule change other than seeking investors in law firms. And maybe someone could explain that in a little bit of detail for me to help me out. Thank you.
I don't know that we know the answer to that question beyond what's in the report. So I would just say to you, Lori, and it's probably going to sound like beating a dead horse, but it's the truth. This isn't a Florida Bar committee. It's not a committee. It's not a project that was started by the Florida Bar. And the materials are there for you to review so you can see the letters leading to this. But at the end of the day, I don't have the answer to that question. We can certainly dig and try to find out. I'm not sure at the end of the day if that's going to really help us at the end of the road, because we still have to vote on these recommendations. But I do think it's important to know what the reason for all of this is, and it's a very valid question. Don't know the answer.
Say, if I may, I think historically, I know this from my national discussions with ethics lawyers, I think historically it's to provide law firms with additional capital
Correct.
so that they can invest in technology and one hopes provide better and more efficient and cost-efficient services. That's just one theory.
I've seen that in the report, Skip. I saw some of the other, comments in the report about access to justice and things of that nature. And I certainly know that you've seen that too. I think that the question that folks have, the question that I have is, for the Florida bar, why are these things being proposed now? That's what I heard from Lori. That's what I heard from Sean. And I attended a couple of these other forums in other circuits, and that's certainly a question that's been raised throughout the circuit. So I do think it's something that we certainly should seek answers to. And you may very well be right.
So we have a question from a member. The report says that initially the Florida bar pays for the lab. Our members would like to understand if their dues will be paying for this lab. The report then suggests that firms and not-for-profit firms will eventually participate in the lab and take over the cost, but it is vague at best as to when that will happen. There are concerns about self-interest and the bar allowing firms and not-for-profit firms to buy their way into this lab and then self-report no problem / issues and get the bar's support to continue operating. Any of our reps want to talk about that?
Yeah,
I mean-
I think that's a legitimate concern. When I was talking about the lab and in the slide, it's a concept, it's an evolving concept. And this is exactly the type of discussion we need to have. We don't, obviously part of this is unintended consequences. And that is certainly an unintended consequence that you raise in the question. So I think that's an excellent point and one that we will take to the committee.
And I'll just say, I have a lot of questions about the lab. I've read the appendices that talk about both the paralegal pilot program as well as the legal innovation lab and how it is managed, who monitors it, what input would the bar have in these processes, what information will we get about how the lab is running and how and when will we get that information. So I have a lot of questions about that I don't have answers to from the report, but I certainly intend to raise those. So I think, as Ron said, I agree, it's a valid question and certainly a valid concern.
Okay, and we have another member question about the paralegal pilot program. So the report says that this program will also be tested in the lab or in a legal aid office. It says that the lab will establish an application, a review process, and criteria for reporting results and data, but we are not given any access to those details. There is concern that the Board of Governors should be able to review the application, understand what the actual review process will be, and the criteria for reporting the results and data before they vote to allow a pilot program like this. Will you guys, as our reps, be asking for these details before you vote?
So we will want those and we will be seeking that type of information. An important point is that this is not a matter for the Board of Governors to vote to implement. This is going to be going to the Florida Supreme Court and for their decision on implementation. So at this point, when we do have a discussion with the special committee, those are questions that we will be asking. And I'm certain that they will be weighing heavily on each governor as they cast their ballot.
But in all fairness, when you guys vote, if you were to vote to approve it, I mean, do you see any reason that the Supreme Court would not accept your vote, given what we've seen in the last year?
I'm not certain if you got a double negative in there intentionally, but we are under the auspices of the Florida Supreme Court, and I believe the Supreme Court recognizes that we represent the attorneys in the state, and we've been elected for that purpose, and that we do have a voice that they should be listening to.
And I'll just add, if I can, Julia, this is exactly why we're doing these forums, because we want to be able to let the Supreme Court know that we have fielded questions from the attorneys in our circuits, and that we have these questions, and that we've made an informed decision when we do vote. And so that's the purpose here. And to reiterate, this is not the Board of Governors report. It's a special committee. And it is very helpful to have all of these questions and concerns to be able to bring to the committee before we do make the vote.
And if I may add one more piece to that, Julia, something that all the attendees may not know. The board works very hard at having a good open dialogue with the court. We visit with the court once a year in Tallahassee. Obviously, COVID has made that more challenging the last couple of meetings that we've had, but we have a good working, very friendly, personal, respectful relationship with the court. None of us can say what the court will do, because the court will do what the court will do, but we work very hard, not just the board, but the bar, at forging a relationship. So at times like these, when the board is called upon to make a recommendation, our voice is more than simply a voice in the discussion. It's a voice and voices of folks that the court has visited with, has broken bread with, and I would like to believe very much respects.
And if I could just weigh in, since everybody else has, I would say that this, to me, it's an underpinning of why it's so important that anyone who has a perspective on this, a concern, a view, whatever it may be, that you express that. From my perspective, we as the circuit representatives felt that it was really important that we ensure that our members' voices are heard and that we hear your concerns. I have my own questions and I have my own concerns, but that's just me and I'm just one person. So I think having, this forum and you all utilizing the opportunities that you have to comment, that's the best that we can do. And then once the board makes its recommendation, and remember there's 52 members of the Board of Governors, I know that we'll all be prepared. I know that we'll all be educated. We will all have listened to all of you. And then we have to vote our conscience and put it in the court's hands. So right now, I think is the really important time frame of getting our questions answered, learning as much as we can about what these recommendations mean so that we can effectively vote.
And getting the additional questions, Saya, like you said, any questions that you all have, let us know. We can't necessarily answer them, but we can ask them.
And by the way, everyone who submitted a question or a comment to me, I have put them all in one email for our Board of Governors representatives, and they have all of them. So a member asked this or was concerned about this. When the report addresses not-for-profit law firms, it gives an example of allowing an entity to be formed with lawyers and non-lawyers that could provide both legal and non-legal services. They specifically mention a nonprofit legal provider that also provides social work, therapeutic services, or job coaching to its low-income clients. There is concern about not-for-profit legal providers offering therapeutic services and the lack of neutrality in those services, among other things. Can the Board of Governors ask the committee whether they studied other states that allow nonprofit legal providers to also allow therapeutic services, and whether they spoke with those providers and actually heard the pros and cons?
Yes, we can ask.
Similarly, the report mentions the possibility of a family law firm employing CPAs and counselors, and then these people possibly having a minority interest in the firm. Can the Board of Governors clarify with the committee what states they spoke to that had actual examples of this working and not being a conflict? Did the committee actually speak with any firms that had this arrangement to hear whether it was good, bad, ugly?
Those types of questions are critical because they'll give us information as to whether something has worked or whether, in essence, this is wasting time or perhaps creating a further problem. And that's something that, unfortunately, this Supreme Court Special Committee's report does not really get into detail. They did have a number of folks that were witnesses that came in from other states, and even a gentleman from England who testified and helped out with them. But on the 50 state scale, that's information we need.
And I also have questions about whether, states that were studied were comparable to our state, because all of these jurisdictions are different, and how these things apply in one jurisdiction may not be the same as how they apply in others. So I think that's a really critical question. It wasn't answered for me by the report, but those are certainly additional questions that I have about whether the states that were studied, how in-depth were they studied, and are they comparable to us?
Yep. So there is also concern about the committee's recommendation regarding education on limited representation. And I believe Michael Gelfand touched on this in his slides. Will the judges be educated? The judges are the ones who can sometimes make limited representation difficult, especially if a matter gets set for a hearing or trial. How does the committee envision this education, and how are new judges going to be educated? Will the Florida Bar be organizing this education on a regular basis?
So that's an excellent point. The focus doesn't need to be just on the lawyers, but actually on the judges that regulate what occurs in the courtroom. The Florida Supreme Court Special Committee's report does not touch upon that, and the language seems to be focused solely on lawyers and how lawyers have retainer agreements or representation agreements with their clients. Again, a very good point that we need to bring up with the court's special committee.
Julia, I don't know if anyone who's on the Zoom, I know there were some questions put in the chat, but if there are, comments that people have outside of questions, they should feel free to raise those as well, because we want to hear them. So I don't want people to feel like they're restricted to asking a question. If there's a comment that you'd like to make, I know from my perspective, I certainly want to hear it so that we can sort of take those concerns, perspectives into consideration when we meet with the
So
team.
Dan Zuniga actually has a comment.
Okay, good.
And kind of question. Dan, do you want to unmute?
Sure. So, and I kind of want to echo what Sean Dominic had said earlier. And I very vividly remember when this came up, and I know a lot of the concerns, and back at the time, the concern was that the vast majority of the members of the Florida Bar are solo small firms, 1 to 3 attorney firms, and that this, and I'm talking specifically about non-lawyer ownership, that this non-lawyer ownership was really going to disproportionately benefit the big firms, and that you're cutting out basically half your members because, no one could explain to me a scenario where non-lawyer ownerships would come with the financial backing that they would give big firms and do that for the solo small firm practitioner, which at the time was greater than 50% of the membership. So again, I echo what Sean said, I don't know why it keeps popping up when it was pretty soundly dismissed not that long ago. So that's a comment, it's a question, whatever, however you want to take it.
Again, because of the court, we were asked to look into that, is our understanding, and we agree it was dismissed, and we're just trying to do our due diligence and be able to answer, vote on it now because it's been brought up again by the court.
Right, but from my perspective, Dan, I think that's a really critical piece of the puzzle. Solo and small firms do still comprise the great majority of our bar, and how these proposed recommendations will affect solo and small firms is significant because that's the bulk and the majority of our membership. So those questions to me were not answered by the special committee's final report. How will this affect solo and small firms? What impact will it have? Do you think these changes are going to benefit them? And if so, how? And so, for me, I think those are very serious questions that we need answers to that are not answered by the report. And we'll find out if there are answers to them.
I just want to also, I guess, remind representatives that, back when they looked at this, they pointed to the accounting firms coming in, really wanting to be the ones to buy the big, buy into the big corporate firms. And people were pointing to, look what happened with, Enron and, a bunch of things, like the ability to cook books. I'm not saying anybody here will do that, purposely or not, but, it's been done, and that was one of the rules that was in place of why they didn't want to have non-lawyer ownership. And I think that still holds true today, that there's a lot of danger out there by people who aren't lawyers and, bound by the same rules of professionalism that we are bound to in ethics. So I'll just leave that as my final comment.
And I'll just say, I agree with that, Dan, too, and the regulatory issues come into play. And I personally have a lot of questions about the regulatory issues and how that's going to be, how that would be handled with this concept. So I think those are all well taken points.
When we look at the report, the focus that you're bringing in, which is a proper one, what's the impact on the bar? That does not appear to be part of the focus of the Supreme Court Special Committee. And how it impacts the practice of law does not appear in the pages. And that's going to be a question that should be answered if this moves forward.
It's also very concerning that the Supreme Court is, kind of bringing this up. Looks like they're doing it just like they changed the rules with the, summary judgment. It's like, it seems like they're, everyone talks about how they don't want to have activists, judges and things, but now you've got the Supreme Court really coming in and seem like they have their own agenda. So I hope that, I haven't seen anything that I think is helpful to attorneys, but I hope that we can express that to the Supreme Court, and I hope they listen. I don't know they will, but I hope they do.
And Michael, just to piggyback on some of what Dan has said too, in the report, the committee actually references the fact that they did a 2021 survey of our membership, and over 81% of us said no to this stuff. And so in addition to what Dan was saying, that we've already been down this road, they even have current stats from us where we did not approve of this. And I think part of why you're not hearing the impact on lawyers is because they specifically said, we understand that 81% of them don't like it, but there has to be change. So we also have some comments from Robin Shear, many of them. So Robin, let's just keep it to a minute.
How about if we just not at all, and I'll just keep doing what I'm doing? Better that I don't talk. It's okay. Thank you.
I didn't see Robin's last comments in the chat. I saw Skip's comments about who appointed the committee members. The committee members were appointed by the Chief Justice at that time. And so, that's the answer to that question. And I think there's some background materials on the website identifying, who was appointed when and so forth. But, at the end of the day, listen, Ron is right. We as the bar, we're an arm of the court and we do our very best to have good open dialogue. But at the end of the day, it's the Florida Supreme Court and it's their decision. So the very best that we can do is to provide as much information as possible about the pros, cons, or what have you about these proposals from all perspectives, from the section's perspective, from solo and small firms, from what impact is this going to have about how, whether we exercise independent judgment or whether we've got someone from the outside coming in trying to tell us to make a business decision. So, I think the more information that we provide, the better. But at the end of the day, we're not the decision makers. And Dan, I hear your concerns. I hear you loud and clear, but I do think that some of that is out of our hands. We're doing all that we can, I think, to try to address this as best we can.
And Saya, maybe you can handle this question from Dean. He just wants to know the process for approval.
Okay, so the process is we'll have 2 meetings with the special committee, one in September and one in October, to address a lot, all of what we're hearing today and our own individual concerns, any concerns that come up in the interim. Again, as I've said, and I know all of us feel the same way, we're here. We want to hear from you. What we don't want is to go and have to vote on this and have folks say, well, I never had an opportunity to be heard about how I felt about it. So we're trying to be as open and transparent as we possibly can about the process. Once we have the 2 meetings with the special committee, President Tanner has set the date of November 8th for us to have a Board of Governors meeting to vote on whether to recommend that these proposals be implemented to the court or not, all or part. And then once that happens, those recommendations will be provided to the court. What happens after that, I can't answer that. I do not know if the court will have a period for public comment or what time period the court will utilize to make a decision ultimately. That I think we'll have to wait and see on that part of the process. I do know that our understanding is that the court will not make such a decision until after we vote in November. So I think we can feel confident that for the time being, leading up to November 8th, those who want to weigh in to us will have the opportunity to do so.
Is there anyone else who has a comment or would like to speak with our representatives?
And I just wanted to say, Julia, feel free, as Saya said, to reach out to us individually as well. If you want to discuss, we're all available to speak to you individually. If you want to discuss this in an individual capacity, I'm happy to listen and take comments. Again, I don't know what answers we can give outside of what's in the report at this point in time, but we are happy to hear concerns.
Jordan Brill, do you want to unmute?
No, I just want to bring that information to light and hope that it's discussed. That's all.
So for our reps, Jordan says, make sure that the potential conflicts of interest which will arise in the context of a non-lawyer ownership are discussed specifically in real property matters, brokers, agents, property managers.
Got it, Jordan. That's a big question for me too. When I looked at that aspect of the report, there were like maybe 3 or 4 lines about conflict of interest. And I believe it referred to, well, the other states that have done this haven't changed back to the old rules, so it must be working. I need a lot more information about how those issues are handled, what potential conflicts arise and how they intend to address them that I didn't get from the report. So I certainly have questions about that.
And Paula Albright, who is actually a former chair of our bar's paralegal committee, she had some questions and comments. Paula, do you want to unmute?
Hi, thank you, Julia. I appreciate that. So I don't know how much anyone remembers when the FRP designation began. We had a vast influx of people who were making that application to obtain that FRP status. And there was more than a few of people who ended up with the status who were not actually qualified. For whatever their reason, their lawyer signed on to the affidavits and things like that. And I raised hell then, so I'll just leave it at that. So I'm a 30-year paralegal. I'm certified by NALA. I'm certified by the Paralegal Association of Florida. I have a specialty area. I would not go outside my sandbox. So, but my concern is I'm sure that we still have a lot of paralegals who have this FRP designation who don't actually have sufficient skills or education or experience to even get to that limited licensing portion, if that makes sense. So for me personally, I know what I know, and I know what my skill set is, and I know that there are a lot of paralegals out there who are like me, and I know that there are a lot who are not. So my concern is what is that threshold for a paralegal? What is the criteria that has to be met? And it's got to be more, and I'm presuming this is being discussed. It's got to be more than just FRP status. There has to be all this other that resides in the back as well. And that's a major concern for me.
Do any of our reps want to respond to Paula?
I'll respond first. Hi, Paula. It's nice to see you. Thank you for your comments. It's been a little while. One of the things that would be helpful for me, and I suspect my colleagues, is the everything else. When you talk about other things that you would expect a paralegal to have, he or she, in terms of the qualifications to even rise to that threshold. And you don't have to provide it to me now, but this would be a conversation that I would welcome, where you and I could talk and you could explain to me, unpackage for me in greater detail. And I'd be happy to share it with my colleagues, what you think that expectation would be from someone like yourself, who's been a leader in our community, 30 years paralegal, has been out in the front of your field. I would really welcome the opportunity to have that conversation with you, Paula. We don't have enough time to do it today, but please, if we could set that up, I'd like to have that discussion.
I would as well. Thank you, Ron.
Thank you.
Thank you, Julia.
Okay, that concludes our forum for today. We will make sure that all of these comments that you have in the chat will provide to the Board of Governors reps. Thank you so much for being with us today.
Thank you very much,
everyone.
Julia.
Thank you, everyone. Everyone stay safe.
Thank
Bye
you,
now.
Julia. Bye.
Thank you, Lynn.